Welcome everyone. It's noon on the second Tuesday of March, and today is our first nuts and bolts session for the Step 2 program for 2015. This year we're going to be having 4 different nuts and bolts programs, and this is the first one. It's an introductory overview. And I just want to welcome everybody. Welcome to both clients and helpers. This is an introductory overview for both clients and helpers. Each of the sessions actually is also for both clients and helpers. And by helpers we mean people who are involved in the plan of a client, and as successor trustees, as executors, or powers of attorney, whatever they may be. They're people that we call helpers, who are people who have roles to play when the plan actually comes into effect. A few administrative things. I'm going to mute everyone, but if you have a question as we're going along, fundamentally I'm going to mute everyone because otherwise we end up with a lot of background sound and people have trouble hearing. So I'm going to mute everyone. If you have a question as we're going along, I want you to be sure to do that. On the right-hand side of your screen, you should see a little red arrow either pointing out or pointing in, and that is the GoToMeeting panel. At the bottom of that panel, there is a section called Chat, and you can type a message in to say that you want to ask a question. I'll be checking that from time to time, so we'll go from there. Alicia is actually on the call. She'll interrupt me if she sees it, because typically I don't always see it when I'm going along through the presentation. So there are actually 3 different parts to our education program. The first part is the trustee training preview. That's part of this is the 3 parts of today's session. First part is going to be the trustee training preview, and by that I mean truly a preview. We're not going to be giving the trustee training classes today. It's just a preview of what the types of things that will be covered. We're also going to go through a client orientation meeting summary, and this is the orientation meeting that people see when they become when they're deciding whether they want to become clients in our program. And the third part is kind of a little bit of fun. We call it the Werewolf Workshop, which kind of ties everything together to explain what exactly it is we're about. So this is really an introduction. You know, it's going to be about an hour, we hope. You have the advantage of being the first to hear this, because this is the first time we've actually presented this particular nuts and bolts. So it may be a little bit longer than an hour. Again, we've talked about the GoToMeeting side panel, and please, if you have any questions, hit the chat box. So, there are actually 4 separate sessions of our trustee training resources. The first of the webinars are usually on the second Tuesday of a month. We're not having it on every second Tuesday of every month. In the spring, it's today, March 10th, and April 14th, which is the second Tuesday of April. And then in the fall, we're having another session on September 8th and a final session on October 10th. So everybody understands what the resources are that are available. There are, of course, the webinars, the 4 of the nuts and bolts webinars that we have. And also, of course, we have the heritagedesignlaw.com website. That is currently under kind of a reconstruction. It will be available in its new format, hopefully within a few days. There will be a button for client sign-in on it, which will lead you to a sign-in for the Step 2 program materials. And in that, after you sign into the Step 2 program materials, you'll be able to see a lot of other information that's pertinent to the Step 2 program. Also, as many of you know, I'm a member of the National Network of Estate Planning Attorneys. The network actually maintains a website called lifespan.com That's the website of the chairman of the National Network. He's an attorney in Indiana, and he is kind of the founder of the entire whole idea of the program that we have. And he has a lot of resources that are available to clients. So you can go to that website, lifespan.com, and you can sign in. It'll ask you what attorney you're signing in with respect to, and all you have to do is type in my name and give them your email address so that they know somebody signed in. So there are really three elements to the program. There's wealth transfer training, which involves the training about estate settlement for what happens when people die, and also settlement when happens when people become disabled. There are a couple of other parts that we'll be talking a little bit about called wealth reception planning, and those are for the receivers of wealth so that they have an understanding of what to expect and what their role is in the plan that that our clients have actually prepared. And then when the actual plan is being implemented, we provide support for the receivers of the wealth as well as part of our program. So there are 4 nuts and bolts programs, and the first 3 are here. The first one is the introductory werewolf workshop today. The next one, which is next month in April, is the death settlement successor trustee training, and that's about what happens, what the process is when someone dies. The third nuts and bolts program is for what happens with respect to disability, and so that's for successor trustees and healthcare representatives. And then I'll talk about the last part in a minute. So what are our goals for the program? What we find is that the primary goal, or a goal that not necessarily is the primary one, but is common almost universally among all of our clients, is that they do this planning because they want to make sure that things go smoother for the people that they have been doing their planning for. And you know, that is fine, but there's nothing that a person who has established their own plan can do once they die, for example, to make things go smoother for the people that are following and participating in the plan. It's really the people who are the beneficiaries, the helpers, who are actually playing roles in carrying out a person's plan that it has to be smoother for. And you know, nobody likes to be inconvenienced, but what happens when somebody either becomes disabled, let's say your mom trips and falls and breaks her hip, or your mom or dad dies, or whoever it may be, your life, if you're close to them, is changed in an instant. None of the things that you expected to be happening tomorrow are actually happening tomorrow. You often have a lot more duties and responsibilities for people that you care about. You might have to deal with decisions about nursing homes or rehab or medical treatment if there's a disability. And if someone dies, of course, there are all kinds of complicated issues that people need to confront about what happens next. So, you know, it's very important for people to get training and understanding so that the primary intention of the people that are our clients actually can get carried out so that things can go smoother. If you don't really know what's supposed to happen, it just isn't going to go well. So here's what I'd like to do is I'd like to start with a bit of a preview on what the trustee training workshops are for. And let me give you a little bit of history. This slide here is actually a slide that is used in the education of National Network members as they go through the program for training, etc. And one of the things that has become very, very normal in our training is that we're trained that it's really not about the documents when we're talking about estate settlement. What we mean is that although there are documents and there are instructions in the documents, it's really all about what people actually do. And so the primary purpose for the training is to help people understand what exactly it is that happens and what they will be doing. It's really not about the documents themselves. You know, one of the things that we feel very strongly is that the value that we provide to our clients, and therefore the value of the fees that we charge is really based on counseling. It's not based on just the documents. Now, when we originally started doing our program some years ago, we really focused a lot in terms of our training on what the documents were, and our clients were very excited about the program, their advisors were excited about the program, and we spent a lot of time talking about the particular documents that are involved in an estate plan and what they mean and what the role of a power of attorney is and that kind of thing. But then when we started realizing that our real value was in the counseling and that the documents sort of come along with what we do, you know, it isn't really about covering the workshop about the paper. It's really more about training people about what to expect and what their job is and what they should be doing and what the process looks like, not really just what the documents are supposed to do. And one of the interesting concepts that has developed over time is what we call the parking lot rule. If you go to a webinar or you go to a seminar or a workshop, whatever it may be, you'll be receiving a lot of information. You might take a lot of notes. But as you leave the meeting and head out to the car in the parking lot, a lot of that information starts to fall away. And we call that the parking lot rule. If we're lucky, we end up remembering 2 or 3 items of things that were actually talked about in the meeting. And so the purpose of understanding things as to the parking lot rule is that the engine of learning and the engine of retention is repetition. So it's important to repeat attendance at workshops from time to time so that you can retain what it is you can learn. And that's one of the reasons that we have these, we record these webinars so that our clients and their helpers will have access to them by download from our website at any time so that they can brush up on what it was that the program was about and the information that they got. So that's the parking lot rule, and that is really kind of the basis for the way we've approached our nuts and bolts workshops in the last couple of years and as we're developing things to go along. So there are really 4 goals for these particular workshops. One, of course, is to know the law firm name and the contact information for us. And so that when you need to contact us, you can, and you'll be able to find out what you need to know. It's also very important that people understand that there is a process and remember that there's a process when things start to happen, and understand that it's the process that produces the results, and so we have to follow it. It's more important to remember that there is a process than to remember exactly what the process is, because understanding that there is a process kind of carries you along, and we're the guide that you would follow through the process. We also want to give people an idea of what the types of issues are that they're going to be dealing with. What happens, what are the issues that you might be dealing with in terms of disability or even for Medicaid purposes? What are the issues that you're going to be dealing with in terms of estate settlement and the process that goes? What are the estate taxes, if there are any? That kind of thing. But also there are a lot of personal issues that come up in the process that are the source of many of the decisions that people make during that process. So it's important to understand the kinds of issues that you're going to be confronting as you deal with estate settlement or disability for the person that has been doing the planning with us. And then finally, we also want to encourage people's interest in planning and the participation in the planning. We'll talk a little bit about wealth reception, and that's helping the people who are the receivers of wealth understand it. And part of this training has to do with understanding how they participate and explaining why it's important to participate. So the 911 information, what happens, what should you do when there is an emergency? Of course, the first thing is to call the law firm and locate the helper's handbook. Now, that's what we call, with our clients, we call that the blue book. That has a lot of the operating instructions for the maintenance program in it, and that has a lot of information about what the assets are as current, and a lot of other information about what happens in terms of estate settlement that our clients have. It's called the Blue Book. All of our clients have it, and that's their operating manual for the annual program that we go through. Then, of course, locate the client's Red Book, and that is the red portfolio book that the clients have all of their documents in. And there's also a list of various different locations where things, important items may be located that helps organize the assistance that you'll be giving to the clients in terms of estate settlement. And then finally, of course, it's important to relax. Remember that there's a dependable process to follow. What our clients want is for when you call our firm when there has been an emergency, that we're prepared and we're there to tell you everything is all set, everything's all lined up. You don't really have to worry about it. When you come in, we'll go over what has to happen, and things will go along smoothly. Now, our goals, hopefully your goals for the program, you can tell us. We were interested to know what your goals for the program are. First, of course, we'd like you to share with us by calling us if you have any suggestions or comments. The reference here to the First Call program has to do with something you qualify by simply having attended this workshop. Our clients have the ability, as part of their program, to call us whenever they have a question about their plan so that they can get a clear understanding and the clock's not on. So if we can answer a question for someone on the telephone, we're very happy to do so. That's what we call the first call. What it means is that we want us to be the first call that you make when you have a question so that you don't make unnecessary mistakes or go down the wrong path too long. So by attending this program, if you are a helper, you have the ability to call us, and you have the first call privilege, so feel free to call us whenever you want to. Also, please send us a private email. My email is fbridges@hdlawgroup.com, and Alicia Sweeney's email is asweeney@hdlawgroup.com. So please feel free to send us a private email, and our clients, of course, have our email addresses, and we're very happy to get that. So let us know what's working for you and what's not working and what you'd like to help with so that we can improve our program. Now, one of the things that it's important for people to understand is that when there is an estate plan, usually people think about it in terms of purely the finances, the taxes and the finances. Allianz Insurance Company a few years ago did a study of what was important to both the people who were in the older generation and comparing it to what was important in terms of planning for the people who are in the younger generation. And by that I mean the boomers being the younger generation and the older generation being their parents. And although the parents in the older generation thought that what was most important to their children and to the people that were their beneficiaries, what they thought was transmitting the financial assets and real estate that they had to them. But what came out of the study was that what was more important to the boomers, the people who are in the younger generation, the receivers of the wealth, was first and primarily they wanted to know more about the life's lessons and values that the person who was their parent or their loved one, they wanted to hear their stories. They wanted to hear what it was that was important to them in their lifetime. And that, also they wanted to have instructions and know what their wishes were, what wishes were that they had that needed to be fulfilled. And of course there's a lot of emotional value and attachment to personal possessions, so personal possessions were a major issue for the receiving generation, and only finally did they get to the financial assets and real estate. So it kind of turned the outlook of the entire planning community up on its head, so that we started thinking about the planning in terms of how the receivers of the wealth were experiencing people's plans and thinking about what the planning was in terms of those people. So we've come up with, and this is a national network concept, we came up with the idea of wealth reception planning. And what that is a formal process designed to assure you and your loved ones that your true wealth, both financial and non-financial, is fully realized, efficiently transferred, and effectively received. So this whole education program is it's partly about wealth reception planning, so that we can assist the people who are the receivers of the wealth in understanding what to expect, what their role is, and all of those kinds of things. So that is wealth reception planning. And you know, the fourth part of the Nuts and Bolts series is all about how to maximize the benefit of your insurance. We have not given that one yet until this year. And that's really designed primarily for the receivers of wealth, so that they understand what it is to be a beneficiary, what the terms of various different trusts mean, what it's like to, and why the planning is done using the trusts and that kind of stuff, and what's the best way for them to maximize the benefit of what they're receiving from the person that did the planning for them. So that's the one that occurs in October, and I hope and urge you to attend that if you're a helper or a beneficiary, so you can understand a little bit better. So what I'd like to do now is to give you a kind of a summary of the client orientation meeting that we have with people who are considering becoming our clients, and it's designed primarily to give you an understanding of what our philosophy is, where we're coming from, and a lot of the why behind why we do our family education program. So the title of our orientation meeting, it's really a slideshow that we go through with people in an individual meeting now with us. It's called The Truth About Estate Planning. And fundamentally, the truth about estate planning from our point of view is that most estate plans just don't work. So what do we mean by that? Well, what we mean is that it really doesn't meet people's expectations, both the people who do the planning and the people who do who are the receivers of wealth. And so, you know, one of the reasons why we do the planning the way we do is that we're dedicated to establishing and implementing plans that actually work. So how do you know whether a plan actually is working or not? If you're the decedent, if you've died, how do you know that your plan worked? Well, you know, if you can come back and talk to me, I'd be very happy to discuss it with you. You'd be the primary client that I wanted to work with, but unfortunately you can't. So we have something called the snapshot test. And what that is if let's assume that you've died and you're up in the clouds looking down, which of course is the better alternative, and you're watching what's happening with the people that you've left behind. If everybody's running around doing the kinds of things that you expected them to do, then that's a plan that worked. And anything else, things that are happening that was not anticipated, that you didn't expect, anything else that's happening is a plan that didn't work. That's unacceptable. So our job is to help people sharpen the scope of their snapshot, understand what it is that they really want to have happen, and work through them on a counseling basis to make sure that snapshot actually comes true. And one of the tools that we use, people, when they do have that sort of vague snapshot of what they expect to have happen after they're gone, or even if they're disabled, it's very hard for them to understand, you know, what the target is. So we have this definition of estate planning as a kind of a target for people to understand what they should be concentrating on when they're taking a look at their snapshot, and that is this: I want to control my property while I'm alive and well, plan for me and my loved ones if I become disabled, and give what I have to whom I want, when I want, the way I want, all while assuring my wisdom is transferred along with the rest of my wealth. Now, it's interesting to note that the second part of this definition is to plan for me and my loved ones if I become disabled. A lot of estate planning occurs primarily focused on what happens after people die, but you know, there's a lot of planning that needs to be done for what happens if someone becomes disabled. So how do we want to be taken care of? Who do we want it to be taking care of us, making decisions for us if that's necessary? So a lot of planning that we do with people has to do with that. It's not just about taxes and what happens to the disposition of wealth after people die. And the last part of the definition here says, all while assuring my wisdom is transferred along with the rest of my wealth. And that gets back to the Allianz study. What we want to make sure is that people have the ability to transfer their stories, their wisdom, the kinds of instructions that they want to leave behind to the people they care about, not just to transfer their particular assets, etc. And this year we're going to be focusing a little bit more on how we can provide a better medium in our Step 2 program to help people with that aspect of their planning. So, all right, we have this definition, we know what the target is. How do we go about, how do we prioritize all of the various different things that we need to think about in answering all of those questions? And the way we've done that is we've established, we have this thing called the estate planning pyramid. And you know, if you have a pyramid, you know that it sits with the base on the bottom, and it's very stable. It's not going to turn over. And from our point of view, the base of everybody's plan has to be the person who's doing the planning, me. In order to understand what you need, who you are, what your family is like, we have to start with you. That's the most important person in your plan. So the bottom pyramid is me. That's the person who's doing the planning. Next, once we understand the person and what their goals and what their aspirations are, we need to understand their family, who they are, what their strengths and weaknesses are, how they can support, what support they might need, and only after that do we start talking about what's preserving wealth. Now, we spend a lot of time in the issue of preserving wealth. That's primarily what our job is, to make sure that the wealth is not lost through one thing or one way or another. We don't spend a lot of time in our practice, because we aren't financial advisors, in helping people expanding wealth. But you know, if someone has figured out that how they can preserve wealth, and there are ideas for someone to, okay, if I can expand my wealth, then they're all ears. They're very happy to hear about it. And so this is why we actually collaborate a lot with financial advisors. This is the area that we work with financial advisors in, because you know, we are not financial advisors. There's a lot of work that we can do together as advisors for our clients together on a collaborative basis. So we have a little story that we talk about when we're talking about this pyramid, and that is, what is the easiest piece of the puzzle? Now, I'm not going to unmute everybody and ask everybody the question, but we often get different answers to that. If we're talking to attorneys and engineers, we often get colors and corners of the easiest pieces of the puzzle. But really the simplest answer to that question is it's the last piece. And maybe an even simpler answer is it's the first piece. Either one of those answers is a correct answer to that question. But for us in the planning pyramid, the last piece is saving taxes. That's the piece that's really the easiest for us to do. It's the thing that we get our training for in law school and otherwise. So, you know, the really harder thing that we aren't really trained about is understanding the individual person, being able to listen to them about their family and help them preserve their wealth. And only when we've done all of those other things, those other priorities, do we need to worry about saving taxes. That's really the easiest thing for us to do. So the planning pyramid helps us focus on the client's goals, and by focusing on the client's goals, we can come up with solutions to their issues, and that makes the planning a lot easier. It makes it less of a completely open-ended process. People understand when they understand what their own goals are. It makes it a lot easier for us to help them work through the kinds of things that they can do, what the options might be, and it exposes traditional planning as kind of upside down. You know, when I first started planning, the first issue in my mind, well, it was all about estate taxes and how I was going to save estate taxes. Well, but if you take a look at the planning pyramid and you just start with saving taxes, you're really turning it upside down, and that isn't a very stable kind of plan. If you only start with saving taxes, oftentimes we never got to the individuals or their families and the kinds of issues that really were important to the people. And often they didn't really know that they could actually talk about those things to us. So that's why we use the planning pyramid, and that's why we try to do the planning the way we do. So in our experience, there are really 4 keys to an effective estate plan. The first one is personalized counseling. You know, if you're really interested in understanding how you go, what you want to do, our job is to help you work through the different types of options and counsel our clients about the various different things that are most relevant to them. We approach it from the point of view of, you know, I'll write, you edit. We know a lot of the options, so if we're talking about the planning, we can go through the various different options, and our clients say, well, I like this or I don't like that, and it's easier for them to actually edit when they're hearing the options from us and tell us what exactly makes sense to them. The second most important thing is proper asset ownership. And by that I mean if you have a personalized plan, if you have a set of instructions that you've put together about what you want to have happen, but your assets are not owned consistently with what the plan is designed to do, then what happens is the plan doesn't work. For example, if you've bought a life insurance policy and you expect the life insurance proceeds to be used for your beneficiaries, but the beneficiary designation is only to one of them, well, that's a plan that didn't work. It didn't go to your trust for the benefit of everybody. It just goes to one of them, and so that plan didn't really work. That really wasn't what you expected. And then, of course, another issue is the formal review process. You know, you can have personalized counseling. You can set all of your assets up front, do proper asset ownership, but over time, things change. Your assets change. The amounts of your assets changed. And so the funding or the titling of your assets can change, and that might not line up with what your personalized counseling or what your plan was, and you know, your personal circumstances can change as well. So having a formal review process so that on a regular basis we make an agreement with our clients on a regular basis. We're actually going to review their plan, review their documents, make sure that they're updated based on changes in the law, etc., changes in their personal circumstances, and we have a regular process for that. And then finally, the issue, one of the effective keys is to control the transfer process. Now, obviously, the person who's doing the planning is not involved in the transfer process themselves. They are. This is when their plan becomes implemented. So it's important for people to know what to do, how to do it, and how to pay for it. If people don't know those things, what happens is they're very, very vulnerable. And so if you don't know what you're supposed to do, and you go to a law office, you go to a lawyer and say, okay, will you settle this estate? And you say, well, how much is it going to cost me to do this? But you don't know what's supposed to happen and how to do it. The lawyer basically is going to tell you a price, and you don't know whether it's a reasonable one or not. So understanding what you're supposed to do and how you're supposed to do it, and actually how you're supposed to pay for it, is extremely important in making sure that the family and the people who are the helpers are in control of the transfer process, along with the people that are helping them. So in order to establish all of those things and to meet those various different keys, we recommend that our clients adopt what we call the 3-step strategy. And the first step is to develop your plan with counseling-oriented planning partners. Now, what we mean is that as we talked a little bit earlier about the collaboration with other financial advisors, not just the lawyer, but actually developing your plan with the various different planning partners. And we see our clients as a planning partner as well. So, you know, what we like to teach people is that when people typically go to the law firm, a law firm to talk about their planning, the first question that the lawyer will ask them is, what do you have? Tell me, if you added everything up and wrote it all down, what would it amount to? And people have a lot of trouble answering that question, often for a number of different reasons. But the reason why the lawyer is asking that question is that if we're the traditional lawyer, there are really 3 types of plans. There's a plan for a married couple under the federal estate tax threshold, a plan for a married couple that's over the federal estate tax threshold, and a plan for an unmarried individual. So what that means is that the lawyer is really trying to figure out which template he or she is going to use in putting together the plan. And if you really think about that, what that boils down to is a word processing approach to doing the planning. Yes, there can be some consulting or counseling, but many, many lawyers, and I have to tell you that this was me some years ago, look at the whole idea of the estate planning to make sure that we save the estate tax, and we don't really consider a lot of the other issues, and it boils down to, well, how are we going to word process this plan? You know, lawyers have computers, lawyers have forms, and you know that you can go online to word process your own estate plan, trust, will, etc., for probably less than $50. So if that's possible, and if all estate planning is basically word processing, why would you go to a lawyer to begin with? Well, our answer to that is that the reason that you go to a lawyer, and most people answer this because I thought it was a responsible thing to do, people are going to see the lawyer for estate planning because they want to deal with certain personal planning goals, not just the estate taxes. So, you know, there's a various different, these are the 5 primary personal planning goals that we find people want to address. And I'm not going to go into them in any great depth, but let me just tell you one story, and that's what we call the babysitter story. You know, when my wife and I were very young, we had our first 2 children, or that's not just our first, but our only 2 children, and they were very young. We ultimately decided that we wanted to go away for a weekend to get away. It was the first time we got away after we'd had our first child, just to be alone. And so my wife's mother took care of the children for the weekend, and she wrote a lot of instructions about what was supposed to happen. So, you know, each of our children had different needs and different timetables in terms of what they were going to eat, what they were going to read, when they were going to go to bed, and all that stuff. So, you know, subsequently, my mother-in-law actually gave us the instructions that she'd received, and it was about 4 pages, single-spaced. We have those instructions here at the office about what was supposed to happen. Here was my wife giving her own mother instructions about how to maintain or keep track of the children. There was only one thing that we left out, and that was what was supposed to happen if we didn't come home. So if you look at an estate plan in terms of it being a set of babysitter instructions, and you know that everybody's children are different, and every time you do babysitter instructions, every time you leave children with someone, the instructions are going to be different because the children are different ages, they have different needs, and that kind of stuff. So the babysitter instructions are going to change a lot over time, and there are going to be a lot of different issues that need to be dealt with. So what we find in estate planning is that the kinds of babysitter instructions that people are leaving behind in their estate planning documents, their trusts, their wills, etc., all have to do with these particular types of planning goals. So the second step in the 3-step strategy is to commit yourself and your family to a formal and continuous maintenance and education program. And why we do that, of course, is because there are certain changes that everybody goes through in their own life over time. The circumstances you're in when you did your plan to begin with aren't the same as they are later on. There are changes in the law, changes in the tax law in particular, both tax and non-tax changes. There have recently been a lot of changes in the kinds of personal protections that the trust can provide, and how we have to approach it. And then, of course, there are changes in the attorney's learning. In the National Network, we get together every 6 months and we teach each other new things, things that we've learned from our new experiences. And it's interesting to note that even our clients teach us new things. If the options that we're aware of are not ones that they want to do, they'll ask us, well, why can't we do this? And then we get the joy of actually figuring out a new solution to a problem. And that's the continuing cutting-edge kind of thing that we like to talk about at our meetings. And then finally, the third step is to secure appropriate assistance for you and your family to transfer your wisdom along with the rest of your wealth. So what exactly is appropriate assistance? In our view, it's 3 different components. The first component is controlling costs. So what are the elements of controlling costs? Of course, the first thing is full funding, making sure that all of the assets are titled, beneficiary designations are designated so that they line up with the instructions that the client has for their plan. Then the second part is proactive trustee training and beneficiary training so that people know what's supposed to happen. In other words, what to do, how to do it, and how to pay for it. That's the fundamental purpose for the program that we're dealing with today. It's proactive trustee and beneficiary training. We also have a proactive engagement approach. All of our clients have an agreement with us where we have agreed to offer estate settlement services on a particular basis, and that is available to their successor trustees and helpers when it's time for them to do an estate settlement. Now notice that it says here the successor trustees hire the assistance of the law firm. There is nothing in the agreements that we have with our clients that requires their successor trustees and helpers to hire us. Our job is to simply to offer the services, and the successors can hire us or not hire us based on what they believe is an appropriate decision. And of course, we also think that one of the main elements of control cost is full disclosure. If you go to an attorney's office and say, here's I'd like you to tell me how much it's going to cost me or my family for you to establish, to settle my estate, what do you suppose they're going to say? Well, typically what they're going to say is, I don't know. And the reason they don't know is because they don't know what the assets are going to look like. They don't know what the titling is going to look like. They won't even necessarily know what it is that you have or what your documents say. So they know that there's going to be a lot of work to be involved in getting up to speed with your plan and what you've put together. In our system, we keep track of all of that information as part of our maintenance program. So when we're prepared to do our estate settlement, we actually can tell clients up front before we're doing, before they're even having their estate plan come to fruition, so to speak, the approach and the fee structure that we're going to offer to their successor trustees and beneficiaries in the settling of their estate. So we take a proactive approach, and we try to provide full disclosure to the clients and their families so that they can have true peace of mind. So what are the factors of overall cost? Well, the first is the cost of the documents up front. Everybody understands that. Then there's the cost of updating, meaning keeping things up to date, dealing with change over time, or the cost of failing to update, which can be very costly. And then there's the cost after death, to transfer the assets, to prepare death tax returns. And these are where, if we ask somebody, how much will you charge me for it, meaning your estate plan, what we want people to understand is that it's important to consider the overall cost of the estate plan, not just the upfront cost, but also the cost to maintain and the cost of estate settlement, to do estate settlement. And so we like people to focus on the rest of the fees. So what does it cost for trust settlement administration for disability and death? What does it cost for the death tax return preparation? What about probate services? All of those things are important for people to focus on. There have been a number of studies done by the AARP, for example. They did a study for what were the attorney's fees in a traditional probate case, the average around the country, and what they found was that the average cost of the attorney's fees for an estate settlement was 2 to 3% of the value of the assets in the estate tax value of the assets if it were a taxable estate, and otherwise just the value of the assets. For a standard living trust that was being settled, in other words, one that was prepared, it may have been funded up front, but over time it's gradually lost its contact with how the assets are held. Things have changed over time. So the average estate settlement cost for a standard living trust settlement was 1.5% to 2.5%, and that was a study that was done by the founders of the National Network, Asperdy and Peterson, a few years ago. And we can actually show you the results of those studies and the published results of those studies. For the heritage planning process, our view is that the overall cost, both the upfront cost and the estate settlement cost, now should be no more than 1 to 2%. Now notice that this is not comparable to the two sets of percentages above it. This is the overall cost both while someone is alive and after we're doing estate settlement. Whereas the first two are really just about what happens after someone dies. So from our point of view, the overall cost of estate settlement should never exceed 1 to 2% of the value of the assets at any particular time. And so for full disclosure, we provide our clients with something called the investment selector or practice evolver, and we have a cost control system that we go through with clients before they actually decide whether they're going to hire us. I'm going to show you the investment selector practice evolver here so that you understand how this actually works with us. Our fees are based on, in terms of the counseling and design up front, are based on 0.5% of the value of the assets. That's a fixed fee. We like to have fixed fees because we know when we charge on an hourly basis, people don't want to talk to us. So those are at a minimum of $3,500 and a maximum of $12,500 now for a base plan. This is not for advanced planning strategies and other things like that. But we like to use the 0.5% as a kind of a standard, a reference point for people to understand what their fees are. And understand that the fixed fee of 0.5% is not fixed at 0.5%. What we're showing you is a range. It's going to be around 0.5% depending on the circumstances and what the client's assets look like. So then the second part of our program is the maintenance and education program. This is what we call the Step 2 program. The first year costs $995. Once people have done their planning with us and their funding is done, they become part of the maintenance program. It's the whole first year is included in their fee. So if they started in, let's say, in July of 2014 and didn't finish until the end of that year, then the following year is entirely included in their fee for the $995, and it's only after that that they start paying an annual fee of $495. Those are charged at the beginning of every year. We send out our bills to all of our Step 2 clients at the end of the year, and they're due on February 1st of each year. So people register for the program. And then for estate settlement, we are committed to a fee structure that says that if we're doing the estate settlement, our fee is going to be no more than 1.25% of the value of the client's assets at the time of death. And if their helpers, if a majority of their helpers have actually participated in the education program, then we reduce the fee to 0.75% of the value of the assets at the time of death. So typically for estate settlement for clients and their helpers who have participated in our Step 2 program, in the education program, there's a 0.5% reduction in the estate settlement cost. And why is that? Because we now are dealing with people who will understand, A, that there's a process, and B, that the process is what actually gets them the results. And so that's the purpose of our program, is to help clients and their helpers to reduce the estate settlement costs. There is another set of fee structure. That's the 1/3 up front, followed by a sliding scale at the end. We've actually never had anybody adopt this structure, this fee structure yet. When they do the math, they really realize that the better deal is the top one, starting at that has a fixed fee at the end instead of a variable fee at the end. How does that work for our practice? Well, it's important for people to understand that we do charge a little bit more than perhaps people expect to be charged on a fixed fee basis in our area, although comparing some of the fees that we do, it's really quite in line from my experience. But by charging a little bit more, we spend a lot more time with our clients. Our process is quite a bit longer. We spend a lot of time counseling and preparing the clients and doing a lot of detail work, so we work with less clients. We work with fewer clients. So the result of that is we typically have a better relationship. We have a longer term relationship, and it's not necessarily that we're earning more dollars. So that's our approach to what we should be doing. We're not a high volume practice. what we want to do is we want to be help our clients have a better relationship over the long term with our clients. The maintenance and education program actually helps us. It's actually priced to cover the overhead for the maintenance and education program. It's not priced for us to make a big profit. It's priced to cover the cost of actually running the program so that we have the people on board who are ready to do the estate settlement when the time is right, and so that the clients and their helpers have actually had the training that they need to have. And so what it does is it assures the team that we have a certain cash flow that comes from the maintenance program, so their position as a client services professional is a lot more stable than if all we had was receivables. Typically, it allows us it gives us more client referrals because we have a longer-term relationship with our clients, and the number of clients who hire us for the three-step strategy for the third step, in other words, estate settlement, is actually higher, because after all, if people know that they're getting a fairly substantial discount on what their estate settlement is, why would they go anywhere else if they know the firm, if we know what the assets are and we know what's supposed to happen, and we've helped train, most people would actually, we get more actually of the estate settlement for the people that we've done the planning for. But remember, again, the helpers for our clients, their successor trustees and beneficiaries, are not required to hire us. It's just that it seems to make sense because of what we've done together in terms of the maintenance program. So the reason for the maintenance program is to help train people. So actually the estate settlement is profitable for us even at the reduced expense. And it allows us to plan for succession and expansion of the practice and retirement, etc. When people ask me what happens if you're not around, Frank, my answer is, well, we have the program here to make sure that the firm is stable, and we've made arrangements with other attorneys to cover for us in the event of a disability. I prefer to think about the option of disability rather than death, but that is the way it is. So that's how that all works. So that's what full disclosure means. I'm not going to go into the details of the cost control system, but we go through each of the fees during the entire anticipated relationship with clients before they actually make a decision, so they understand all of the fees, how much it's actually going to cost on a monetary basis to do maintenance and to do estate settlement, at least on a projected basis. So all of that's controlled up front, is disclosed up front. And so the purpose of this all is really so that our clients can have true peace of mind. They'll know that with their helpers and beneficiaries trained and understanding what to expect, things are much more likely to go smoothly, and that their snapshot that's been sharpened with us is actually more likely to happen the way that they wanted it to do, and so their plan is going to work. Now, one thing that we do ask, we do want people to ask, is when they're doing the estate settlement, are we the right ones through age, experience, personality, values? That should be asked when we're doing planning with people, when they're deciding whether to hire us or not. We want to make sure that they've actually considered all of that. But there's one other set of questions that we ask our clients, and that is, are you the ones? If we're making a commitment to making sure that their plan works, or at least doing everything that we can to help them make the plan work, then we also ask our clients to make commitments to us that they will actually attend the program, that they will actually participate in the maintenance program. They're not required to do that. They can re-up for it every year. But when they do, we want to make sure that they actually participate, and that they're going to use their best efforts to get the people who are involved in their plan, their helpers, to actually participate as well. And I think you can see why they want to do that. They want to make sure that their helpers actually have the advantage of a reduced estate settlement cost, and that's a major incentive. But also making sure that things go smoothly and people have less stress because they understand what's supposed to happen, and it's not just this big mystery when all of this upset is happening. The worst time for people to learn about what's supposed to happen is when there's been a death or a disability. That's when things are in the most turmoil, and that's when it's the least likely that you're going to be remembering or able to learn anything about what's supposed to happen. So being prepared beforehand is really an important thing. And the question then is, will you honor the process? Once you understand what it is, will you actually honor the process that we have established for the estate settlement so that it actually does go smoothly? So that is the three-step strategy. Securing appropriate assistance is not actually estate settlement. Please note, you can't secure appropriate assistance for you and your family unless you're alive. So the third step is actually helping set up the team of people who are actually going to carry out your plan. Those are your helpers. Those are the people who have powers of attorney. Those are the people who are successor trustees, so that the appropriate assistance, besides the attorney and the accountant that we'll be collaborating with, the appropriate assistance is all put together so everybody is in place when something happens. Because when somebody dies and their loved ones call us, our clients want us to be able to say to them, okay, everything's in place, everything's all set, you don't have to worry, believe in the process. So this is I'd like to get to the kind of fun part of this, and that's what we call the werewolf workshop. So here's the question. Think about these things. How do you like horror movies? We find that people in my age group don't like horror movies that much, but what we mean by horror movies is the old black and white ones, the werewolf movies, the Frankenstein movies, all those ones with Bela Lugosi and everybody. Though not the more recent slasher types of movies, but the horror movies, the good old horror movies that we can remember in black and white. So how do you like more horror movies? And are you familiar with them? So really the question is, how would you like to star in one? What happens when somebody dies is that, we've got a big problem. There's a disaster. And so when someone dies, if someone becomes disabled or someone dies, then the people that they care about them the most have the greatest difficulty, and everything is in a turmoil. It's very difficult for them. They're confused. They don't know what's supposed to happen next. Their life is completely turned upside down. Nothing is the same. And so it's a disaster. So in a werewolf story, there's a background and a storyline. The background, you get to know the beginning of the movie, you get to know the hero, and you get to know the various different people in his or her circle of friends. There's a storyline. Usually there's a kind of a romantic connection between the hero and maybe a girlfriend or whatever that is. And so that's all set up so that you understand and have a general understanding of who the person is that's the star of the show, that's the actual person that's going to be involved. There's also a cast of characters. What happens, and let me just change the sequence here, what happens once you've been through that part of the movie is you have the attack, and person gets bitten, and now they've been bitten by a werewolf. And so what we have as a cast of characters is we have the survivor, the person who survived the attack, and then we have the people who are their friends, the people who know. Usually in the werewolf movie, there is a friend who knows everything about werewolves. At least they've found out somehow, or they knew it beforehand. That's the friend who knows. Then there are the advisors or the experts. Those are the people who are the scientists who say, it's not possible, werewolves do not exist, this didn't happen to you, there's no medical condition like this, there's nothing for you to be worried about. But of course, the survivor is. And then there's the loved ones. Those are the people who care most about the survivor. Often it's the girlfriend or boyfriend of the person who's the victim of the attack. And so we have our cast of characters. And that's what a werewolf movie is sort of like about. So my next question to you would be, if you want to think about this, how would you kill a werewolf? How do you kill a werewolf? Well, when we give this presentation as network members to groups in person, usually the answer to that question is, well, you drive a wooden stake through them. Well, no, actually, that's the vampires. The vampires seem to have done a lot better marketing than the werewolves. The vampires are the ones that get the stake through them. It's something else, and that is a silver bullet. One of my colleagues likes to recite the story that he said, okay, so who shoots the silver bullet? And the answer from the back of the room was, the Lone Ranger. But no, that wasn't the right movie. The real answer to that question is it's the loved ones who shoot the werewolf. Now, what we're talking about here is we're not asking you to learn how to kill your loved one, kill your mom or dad or whatever it might be. This is really all about how to control werewolf behavior, because what happens when someone's spouse dies or someone's parent dies, the person who's left behind, who cared most about them, is completely in a turmoil, as I said. Everything is upside down. Everything is topsy-turvy. The person that they've lived with all of this time is gone. The house isn't the same. The daily activities aren't the same. If you're the person who's the helper for someone, let's say your mother or your father falls and breaks their hip, all of a sudden your life has changed. You now have issues relating to what's the treatment going to be? Do we have to go to rehab? Once we've been in rehab, are we going to go to a nursing home? Is there sufficient care at home? How is the person going to get around in the house? There's all kinds of issues that are faced by people who never had to worry about that before. It's a life-changing circumstance. Whether it's a disability or it's a death, the people who are left behind, the people who loved the decedent, are the ones who actually get bitten by the werewolf. And so what we find is, there are various different stages of recovery from this, and it starts off with anger, and there's a few others. And so what we find is that people, when they begin the estate settlement process, we can have these lovely surviving spouses, women or men, people that we've known for years, and all of a sudden they become angry and resentful, confused, often suspicious, and that is what we call werewolf behavior. So it's the job of their loved ones to remind them, because now they've had some advanced preparation for this, to have proper expectations. It's the job of the loved ones to kill that kind of behavior and say, wait a minute, this is the plan that you put together, this is the process, you understand what the process is, this is what you decided to do, so things are going to work out, just trust the process. And so we rely on the people who are the helpers to help the person who is the most affected, the person who's bitten by the attack, through this very, very difficult period. We can do a lot of technical things for people, but that first time when people are actually going through this very difficult time is when they need the people who are around them to help them. So, what happens though, what we do find is that, we have the survivor, and then everybody else that they know or knew, they're the friends who think that they know. And there are advisors, there might be financial advisors, accountants, or even other attorneys. Everybody thinks they know, and so what happens is that the survivor comes in, or the person who's been bitten by this attack, the loss of their loved one, comes in, and they're starting to tell us, well, I thought this was supposed to happen, or I thought that was supposed to happen. And what's happening is that they're talking to people who think they know, but they really don't know everything about it. Well, isn't there something you're supposed to do within 9 months after the date of death? We get a lot of very odd kinds of stories from people who aren't really that familiar with the estate settlement process, and those people will have an influence on the survivor, and so they'll come to us and they'll talk to us about this in a resentful way or whatever it might be. And we've invented a character called Marge, Marge is the friend who knows. Marge holds court at the local um, coffee shop or wherever it is, and Marge thinks that Marge knows everything, but doesn't. So actually the friend who knows is us, and it's our job to help the survivor through this process of dealing with the attack and the loss of their loved ones. So when someone comes in and asks us these questions, we'll ask them, well, where did you hear that from outside this process? And so you talk to Marge. And it's a nice kind of humorous way to approach the fact that there's lots of misinformation out there. People don't necessarily know what it is that we're actually going to be doing in the process. And it's the people who are the helpers who have been trained who actually know the process from the inside, or at least that there is a process that can help the survivor through that critical period. So that's the purpose of the Werewolf Workshop. It's to help you understand why it is it's important for people to get a basic understanding of what the process is and the kinds of things that they need to do. So just to review the Trustee Training Workshop preview, remember, we started off doing trustee trainings with a lot of document-oriented things, but now we try to be a little bit more practical about what actually is supposed to happen, what the specific experiences are that people are going to go through, what to expect. And we asked people to actually repeat the program because of the parking lot rule. So it's important for people to know 4 things: how to get in touch with the law firm, what our contact information is. Remember that there's a process, and the process produces the results, so we need to follow it. And to give you an idea of the types of issues that you might deal with, that's what the training workshops are for, and to encourage interest in the planning that the people, our clients, are actually doing, so that their plans actually, their snapshot, their expectations actually do get met. And of course, just to remind you, the 911 of an estate plan is, first thing you do is you call the firm so that you notify us that something has happened, somebody's had a disability, so that we can get started with understanding what's the next steps. Locate the blue book that the client has that talks about the operation of the maintenance program. Locate the client's red book, which is where there's a table where all of the other documents are located, is sort of described. And then to relax. Remember that there's a dependable process to follow, and that it's our job to help you through that process, and we're going to do the best we can. Our job, when someone does call us, is to be able to say, all right, we're all set, everything's prepared, we're going to get started, and whatever is going to be best in terms of the things you need to address first of all in that first critical period through time when things are just happening lickety-split and very, very fast, and things are so confused. Our job is to be a point of stability and kind of say, all right, everything's all set. When you're ready to come in, that's probably going to be somewhere between 2 days and 2 weeks. When you're ready to come in, we're ready to talk to you. Come on in, we'll go over what needs to happen. We'll talk about the process and get started with the things that you think are the most critical and you want to address, and be prepared for the other things that are going to come down the pike. So, does anyone have any questions? I'm going to unmute everybody to see if there's anybody who has any questions from what we've talked about.
Frank.
Yes.
It's Sheldon. Can you tell them the story about the bus?
Well, I had a decision to make about whether to tell the school bus story as part of the presentation, but I figured it was going to take too long, so I didn't. I just told the babysitter story. But if you'd like, I'm happy to tell the school bus story. So here it is. The school bus story is based on the understanding of 2 things. The first thing is that you can assume that I died, and the second thing is that under the law, you can't transfer assets to a revocable living trust and expect those assets to be protected from creditors. So here's the story. First thing that happens is that I die, and I have a will that gives all of my assets to my lovely wife, Carol. And so she goes through the estate settlement process, and she receives all of the assets, my insurance, my retirement accounts, my cash accounts, and all that kind of stuff, all the assets that I had. She receives them through my will outright. So then a few years down the road, she's driving down the road, and it's a rainy day, and she's distracted for a moment, and when she looks up, she sees a big yellow school bus right in front of her and slams right into it. Now, what happens then is you've got Channel 5 out there looking at the 25 little kids who've all been injured, and the question then is, all right, well, what happens to all those assets that I gave her when I died? Well, there is a story of a colleague of mine in Ohio that there was a judgment in a school bus accident like that of $115 million. You can't insure over that. So what we expect to have happen is that all of those assets are going to end up going out to the plaintiffs, and my wife will have lost the things that I've left her, merely because her life has changed in just an instant because she had a moment of distraction. So that's the first part of the school bus story. And so, suppose that there's lots of different ways for me to give her the assets. Suppose we had them as joint tenants. Let's say we had our house as joint tenants, and she was the joint tenant with me. Well, when I die, she becomes the whole owner, and that becomes part of those assets that could disappear to those plaintiffs. Same thing with insurance proceeds. Same thing even with IRAs. Although it's not clear from a spousal inheritance, there's been a recent case that even IRAs that are inherited are not protected from creditors. So it's not necessarily so that just my wife's inheritance of my IRAs would not be protected, but that's coming down the pike, and we're concerned about it. So there's lots of ways for all those things that I left my wife to disappear because of that school bus accident. But suppose that I had set up a trust for her, and the trust says that it's supposed to be there for her. She can be a trustee. She needs to have a co-trustee, but she doesn't own the assets. And so when the school bus accident occurs and the plaintiffs come along, those assets that I left for her are in a separate trust for her benefit. She can get the benefit of them from the distributions for the trustees, but she does not own them. And under the law, because they're owned by the trust for her benefit and for the benefit of the successor beneficiaries after she's gone, because it's owned by the trust, the plaintiffs in the school bus accident can't get at them. So in our Truth About Estate Planning class, when we tell this story, we often ask clients, is there anybody in the room who would not like to receive their assets that way? And typically we do not get anybody raising their hands, because everybody then says, well, I'd like to have a school bus trust. And we find that people who are beneficiaries prefer actually to receive their assets in the form of a school bus trust, because they're not going to disappear from the school bus accident. They're also protected from divorces. They're also protected from third-party creditors, and also they can be protected from the high cost of having health issues in later parts of life, or even during your youth. So that's the school bus story. Did that answer your question, Sheldon?
Yes, excellent. Yep.
Any other questions? All right, well, I don't hear any other questions, so I'm going to conclude today. If you think of a question that you want to have answered later, feel free to call me. Our telephone number is 617-630-5700. My extension is extension 1. And you can feel free to call and ask any questions about this anytime. It's probably going to take a couple of weeks before this recorded presentation gets online. And when it is online, there will be accompanying it an attendance sheet, sort of, that people can answer. It will be a little quiz that people can, when they actually listen to this online, they can take the quiz and send it in to us so that we know they actually participated. It's not a difficult quiz. It's just 2 or 3 different questions to make sure that people have attended. But of course, everybody who's on this call who is a helper, and if you're a client and the helper is with you, please let us know. Everybody who is on this call doesn't have to go and reattend this unless they want to. They have the first call privilege, and they have satisfied that issue of making sure that the settlement discount is available, at least as far as their participation is concerned. So if there are no other questions, I'm going to conclude this. Did I hear somebody trying to pipe up? Okay, so next steps, forward your email address to Alicia Sweeney, asweeney@HT Law Group. If you are a helper, we can put you into our helpers list, and you'll receive notice of the next nuts and bolts classes. So watch your email for nuts and bolts. Our clients will be receiving notices of those. And so, you know, we look forward to hearing from anybody that wants to get notice of the contents of the program. When you do get it, we're going to be putting together a helper beneficiary data sheet so that we can have more information about the helpers and the beneficiaries. So we'll send it out. That's absolutely voluntary, but we'd love to have it back from you. And thank you very much for attending. Okay.
Thank you.
So everybody, have a good day, and thanks very much.